I'm Martin Cocker, I'm the CEO of Netsafe, and this is my colleague Marissa Flowerday, who is the legal advisor for Netsafe. Netsafe is an independent non-governmental organisation incorporated in 2001 and appointed to the role of approved agency under the Harmful Digital Communications Act in 2016. I should note at this point, just for clarity, that the HDCA, Harmful Digital Communications Act, has both a criminal and civil resolution process which can be run in tandem or separately, and the approved agency, therefore Netsafe, plays a key role in the civil process, whilst this amendment is to the criminal section of the Act. As the approved agency, we're responsible for running a proactive public education program and a reactive service designed specifically to achieve quick and effective harm reduction in response to HDC reports. We're also specifically tasked with developing relationships with local and international partners and to strengthen the services available to people within New Zealand. And additionally, we undertake research with that same goal in mind. We assist nearly 3,500 people per year through the HDCA service. Around 15% of those reports have a component that relates to the non-consented posting of intimate images. And our research has found that New Zealanders consider non-consensual disclosure of intimate visual recordings of another person to be one of the most unacceptable types of online behaviour, which brings us to our position that we in general support the offence outlined in the bill. We do believe the bill would create a positive change in social behaviour and lead to less harm. However, we do want to be realistic about the volume and complexity of the issue. Our research shows that 10% of adults send nudes to another person and that around 5% will share someone else's intimate images with another person annually. We know that young people especially tend to engage in risk-taking behaviours, including this one, during youth development, whether through identity construction, sexual exploration or relationship building. And in 2017, we found that 18% of 14 to 17-year-olds admitted receiving online nude or nearly nude images they didn't ask for, while 3% admitted to sending intimate images of someone else. And as such, we suggest the committee ensures that the implementation of the bill's provisions include additional resources for public education to support the implementation of the legislation and the overall policy goal of reducing the level of online risk and the potential for resulting harm. And we've also recommended that the committee ensures that children's position in relation to this bill is considered using a child's rights impact assessment. A non-consented posting of intimate images includes more than what people commonly refer to or think of as revenge pornography. And we agree that the bill will most significantly protect women, but that it is also worth noting that it will benefit men. In terms of simple numbers, we found that males and females are equally likely to experience threats of and/or the actual sharing of intimate sexual content, although in real terms, those experiences are typically quite different. Women are more likely to be targeted by an ex or current partner for the reason of revenge or as a means of control, whereas men are more likely to report the behaviour being directed at them as a joke by friends or by strangers for the purpose of more traditional extortion. We also note that the initial sharing of content is often consented and without harm, and that it is the subsequent unconsented on-sharing of these images or threat to do so that causes harm. So we fully support the amendment bill, but there are a few points that we think could be added and clarified, and I'll hand over to Marissa to pick up from there.
Thanks, Martin. Martin has already expressed our general support for the bill, and I'm going to outline 5 suggested amendments to the bill and the Act. These are legal points which we have gone into more detail within our written submission. The first one is in relation to giving consent. We support the requirement in the bill that express consent must be given, and that consent must be given voluntarily and in full knowledge of how the recording will be used. However, we'd like to make sure the onus doesn't inadvertently fall on victims who are already suffering harm and distress to prove that they did not in fact consent to the posting of an image. Therefore, we'd suggest that the consent must be recorded in some recoverable way and that the onus to have this proof should fall on the person who is doing the posting. This then leads into the second point which we have, which is around online content hosts that are either allowing the sharing of these images or they're operating platforms where these images can be shared. And we know that often intimate images are shared where there is limited contact between the victim and the person posting. If a person doesn't know a person whose image they're about to share well enough in order to get consent, then they shouldn't share it, and it will be an offence under this bill if they do. But to assist in reducing the sharing of harmful content, we consider that there is a role that online content hosts and sharing platforms could play to ensure that express consent has been given. And Facebook is already trialling a tool which helps to reduce the posting of non-consented intimate images. We think that platforms that allow the posting of intimate images should encourage users to ensure that they have the required consent before posting and sharing an image. And if they allow the posting of images without the consent of the person, this offence should apply to the platform too. So we suggest making an amendment to section 22A2 of the bill to expand it to include making it an offence to control or operate a platform that allows or encourages non-consented posting of intimate images. And we've gone into this in more detail within our written submission. The third point we think is that we think that the definition of intimate visual recording needs to be expanded slightly to incorporate the use of synthetic media, which has become prevalent since this act was passed. So for example, this would make it clear that an intimate visual recording would include what has been colloquially referred to as deep fakes. So these are highly convincing images where a person's face has been superimposed over an image of a body in a pornographic or intimate position. And so because of the convincing nature of these types of images, individuals will still suffer significant harm if they're involved in these images. So in summary, on this point, around the definition of intimate visual recording, we suggest making it clear that it includes synthetic media, and also expanding the definition so that it refers to more than one individual, because there are arguably two individuals that are harmed, one with the face that's being shown and then the other with the body in the intimate position. Our fourth point is around the consistency of penalties under the current section 22 and the proposed section 22A. So the maximum penalty for a breach of the proposed new section 22A is up to 3 years imprisonment. So in comparison, a person that breaches section 22 of the current act is liable for imprisonment up to 2 years. So we'd suggest that the committee considers making the maximum penalty under section 22 of the act consistent with the proposed maximum penalty in 22A to reflect the seriousness of the harm that occurs as a result of the digital communication. And then our fifth and final point with the legal focus is that we suggest amending section 22 of the Act to remove intention to cause harm. We support the focus in the bill on the impact of the action which causes the harm, as opposed to the intention of the person posting the digital communication. So we suggest that section 22 of the current wording of the Act is amended to remove the requirement of intention to cause harm. And in our experience of dealing with victims who are harmed by digital communications, is that having the extra burden of proving that a person who has posted the digital communication intended to cause harm places an unnecessary burden on the victim who is already suffering that harm or distress. And so I would suggest making that amendment to section 22 of the Act. Now I'll hand back to Martin for some final comments.
Yeah, thank you, Marissa. Look, it wasn't specifically part of the amendment, but I thought whilst we're here discussing the Harmful Digital Communications Act, it was sensible to add this particular piece of, or this particular recommendation. We have had a look at how the civil process within the bill could also better serve victims of image-based sexual abuse. The civil process is focused purely on harm reduction. It has no initial punishment component, and there are situations where the targets of IBSA, image-based sexual abuse, would like to have their situation resolved, but would prefer to do so without the prosecution of the other party. The approved agency is tasked under the legislation with providing a process of, through resolving cases through a process of advice, negotiation, mediation, and persuasion. And in the event that that process is unsuccessful, the victim can then take the complaint to the district court. So therefore, the effectiveness of the approved agency process is underpinned by the possibility of and likely outcome of legal action if resolution is not achieved. And where the threat of further action appears more significant, producers of harmful content can be more easily persuaded to voluntarily take remedial harm reduction action. The court process can be slow and intimidating for victims, especially when they are already suffering harm. And if the producer of the harmful content believes the system is inaccessible to the victim for any reason, we therefore lose our ability to be persuasive and reduce harm. So to further reduce impact on the court system, to achieve quick and efficient means of redress desired by the Act, and to encourage more producers of image-based sexual abuse to voluntarily take remedial action, we've suggested reconsidering the concept of a specific HDC tribunal that was proposed in the original Law Commission paper back in 2012.